Welcome on behalf of Cassels. We're delighted to present to you over the next hour and a half our Aboriginal and Regulatory Law Update 2020. We've got a limited amount of time, we've got lots of content, and we've got many participants. So the intro will be very brief. I will say that we have designed this in such a way to leave some time for questions at the very end. We welcome questions, and hopefully we'll be able to get to as many as we can towards the end of the session. I thought I would just mention now, you will be receiving a follow-up email with the PowerPoint presentation, biographies. There will also be some of our more recent legal updates that we've done relating in large part to the subjects that are going to be discussed today. Very briefly about our firm and our national Aboriginal and regulatory groups. We have active projects and assignments in every jurisdiction in Canada. We work primarily for industry, really every imaginable type of industry group, coast to coast to coast. We act for federal, provincial, territorial, municipal, and regional governments. And in more recent years, we've been doing some work with Indigenous groups, particularly the Métis in Saskatchewan and British Columbia. The group that you're going to hear from today is not the entire group that works in the Cassels regulatory and Aboriginal space. It's a sliver, an important sliver, but nevertheless a sliver of our broader team. I will very briefly introduce, in the order of appearance, the Cassels lawyers, so that again, once we get into the flow, we'll just keep rolling. So my name's Tom Isaac, and I'll be speaking on traditional and hereditary governance regimes for a few minutes to start it off. And then we'll be turning it over to Aaron Hoekstra, who will be talking about a duty to consult and some of the recent case law relating to funding duty to consult and triggering the duty. Aaron works really in all aspects of Aboriginal law across Canada, dealing with negotiations, commercial work, litigation, and duty to consult more generally. We'll then have a discussion on the United Nations Declaration Rights of Indigenous Peoples. Grace Wu will be joining me on that. Grace just recently joined our team, like Aaron, solely focused on practicing in the area of Aboriginal law. From there, we'll go over to recent trends in regulatory and environmental law. Leading that discussion will be Jeremy Barretto, who also leads Cassels' regulatory group. I like to describe Jeremy as a triple threat in terms of regulatory, environmental, and Indigenous law, and an immense amount of experience dealing with projects across Canada. Viviana Berkman will be joining him in that presentation, and Viviana, like Jeremy, practices regulatory, Indigenous, and environmental law. From there, we'll go to a presentation on current trends in Aboriginal title litigation. That discussion will be led by Mary Buttery, who's a senior litigator who, in addition to working on a series of Aboriginal legal pieces of litigation, has a very robust practice in insolvency and other commercial litigation matters. Joining her is Jared Enns. Jared, like Mary, works on a wide array of commercial and insolvency related issues, but in particular has been adding some real focus on a couple of pieces of litigation. In particular, you're going to hear from both of them today on Aboriginal title litigation. And then finally, to round us off, will be Emily LaHaye, who works again solely in the area of Aboriginal law across Canada, focused on negotiations, litigation work, duty to consult, justice issues, governance issues. And you're going to be hearing from her today on some recent developments in Métis governance that we think are relevant. So before I start, again, maybe just for another minute before we get going, you know, obviously the country's been faced with a crisis this year with the COVID-19 pandemic, but it's very interesting. And what we've seen in regulatory and Aboriginal issues across Canada is a substantial uptick in activity, notwithstanding what has been is obviously a very serious crisis for the country at numerous levels. And it's been really quite astounding in terms of what we've seen as a group, and it has not been subtle. Projects still being planned, projects still trying to go through the regulatory process. And I would say that we've also seen a significant uptick in litigation or threats of litigation. And one in particular I'll comment on that I think for years I've been commenting on, expecting to see it, and we are now seeing it, where project proponents are litigating or pushing back significantly on Crown decision makers for lack of certainty and sort of explaining to folks that governments that their regulatory processes also have to reasonably safeguard against administrative abuses within the context of duty to consult in particular. So it's been very interesting. And my only final comment, I think, by way of kicking it off, we seem to be a country of extremes in this area. You know, we've got some jurisdictions that we operate in where you actually have to remind the government or the government decision makers that non-Indigenous proponents also have rights to fair process, transparency. And we've got other jurisdictions in Canada where it's as if the Constitution was never amended in 1982, particularly Saskatchewan and Manitoba. They seem to be the poster children for really ignoring the reality of our great country and the constitutional amendments of 1982. And these sort of polar opposites really generate a large part of the work that we do. And in the middle is a whole bunch of very positive deal work where people are trying to get along, whether it's government and Indigenous peoples or Indigenous peoples and corporate Canada. So that was a very brief run through of a few introductory comments, but let's just jump right into it. So the first presentation, and again, this will be brief, but we really thought this year it was important to touch on the issue of Indigenous hereditary and traditional governance regimes and what these issues mean for project certainty. I've been able to see who's online and who's signed up for the presentation today. Many of you, we know, have had experience dealing with traditional forms of governance among Inuit, Métis, and in particular First Nations across Canada. And it's common for many Indigenous peoples to have traditional forms of governance, traditional laws, hereditary systems of organization and decision making. One of the key points that we take away, and it's probably a trite point to be made, but it's an important point, is generalizations in this area should not be made. And we do tend to see, particularly public governments, making sort of generalizations around, you know, we are in favor of traditional forms of governance as sort of a broad-based commitment. But what we know is, and really out of respect, I think, for the Indigenous peoples, that each one of these nations or the groups or the communities are distinct, and their particular forms of decision making, to the extent that they're based on traditional or hereditary forms of governance, are quite unique. And I think the only generalization that certainly I'm comfortable making is that they're all unique and distinct. And that therein lies a key message about the need for due diligence for whether it's a public government or industry dealing with an Indigenous government to understand if there are traditional forms of governance or decision making at play, and if so, what they are, and having respect, healthy respect for them. This is an emerging area of study and action for and by Indigenous peoples. And again, probably a trite point for those of you out in the field, but this is an issue to keep our eye on. It's moving rapidly, and we'll talk about a particular example in just a couple of minutes. And we certainly see some nations, some communities very advanced on this issue, whereas others may not be involved at all, and it goes to the point of the distinctness of it. But there does seem to be a convergence of a particular conflict developing, and that is the conflict between democratically elected leadership and governance versus hereditary, customary, or traditional forms of authority. And so, and this isn't across the board, but we are seeing it. There are examples that we've dealt with in British Columbia. There are examples we've dealt with in the Northwest Territories. There are examples that we're dealing with right now in Ontario, where the democratically elected leadership or governance regime of a particular, in this case, First Nation, and both the examples that I'm thinking of right now, are there is some express form of conflict or confusion with their desire to also pursue some degree of hereditary, customary, or traditional form of governance. And the question for public governments and for companies or project proponents is, how do you deal with these issues? And in particular, how do you deal with them within the duty to consult, for example? Until recently, there's been very little recognition under Canadian law around the role that traditional governance or hereditary regimes may play. And again, as many of you will know, there's even been a banning historically, this is part of our sad history of a country, of banning certain traditional activities. And I put up again one of the very obvious ones out of British Columbia among the Coast Salish is the potlatch, and the banning of that traditional activity for many decades in this country. In Delgamuukw in 1997, leading Supreme Court of Canada Aboriginal title decision, we know that traditional governance regimes of the hereditary chiefs of the Gitxsan and Wet'suwet'en were recognized as having standing to pursue a claim of Aboriginal title. The Wet'suwet'en, for example, are 6 First Nation elected bands pursuant to the Indian Act, plus a hereditary governance system made up of 5 clans. Under the Indian Act, we also know that First Nations have the option of creating custom election codes, and more than 50% of First Nations in Canada are guided by some of that custom election code. Modern treaties also make reference to traditional forms of governance, for example, the Niska Treaty, and this is an older decision, but Thomas and Norris out of 1992, it's a BC Supreme Court decision. But the issues of individual charter rights converging with claims of traditional forms of governance, and in this case, the argument that was being made is that traditionally, this particular First Nation at issue, it was argued, was able to, in this case, grab people and basically kidnap them for a series of days to sort of cleanse them. In this particular case, the court held that their individual charter rights trumped whatever rights that may have existed. And of course, the role of Section 25 in the Charter, we still are in the infancy, notwithstanding that this came into effect in '82. Section 25 says that the Aboriginal and treaty rights of Aboriginal people of Canada are derogated or abrogated by charter rights. And so again, understanding that balancing, we are at the start of that discussion of what that may mean. At its core, the role of core democratic values and some forms of traditional governance seem to be in conflict with each other. And we see this playing out with the Wet'suwet'en example, which I'll get to in a minute. I thought it would be very interesting to take a look at a quote. And again, this is meant to be in brief summary form, but a quote from the British Columbia Court of Appeal. And there it said, 2007, dealing with the GICAT, the fact that the legal representatives of the band council, should choose for political harmony to take direction from hereditary leaders does not change the nature of the legal authority of the band council, nor does it establish that there are 2 separate entities recognized in law. And I want to be very clear, I am not suggesting that this is in fact the de facto law across the country. But it's one of those examples that crystallized in a relatively clear statement of the court based on the facts presented in this particular decision, where the court, balancing the democratic form of government imposed by the Indian Act versus the argument that the hereditary leadership also had a valid role to play. In this case, the Court of Appeal quite clearly landed on the side of the legal authority. The final couple slides here. The issue of conflict relating to traditional forms of governance can be challenging for proponents of projects and governments. So, you got the objectives of reconciliation, good relationships, and respect with Indigenous peoples, but they can come up against fundamental principles around core democratic values. For example, signing a large impact benefit agreement and wanting a community ratification vote. For example, individual charter rights and project certainty. And these are just examples. Within projects, we know that the law from Supreme Court of Canada and the Bain and Moulton contracting decision is clear that the representative of the rights holders is the appropriate entity. There isn't an obligation to consult with individuals. But what does that mean practically? And that can be a very different issue in terms of who to consult from a risk mitigation perspective. We are on so many files where we may be given the list of the formal designated groups to deal with. And in some cases, they may include hereditary governance regimes. In many instances, they won't. But does that actually deal with the practical risks that a project proponent may be facing in terms of dealing with maybe powerful families that aren't in power at the time, elders, and other traditional forms of governance and organization and power within a community? And this is something that, again, I think everybody on our team would agree with, that there's sort of the strict law on these issues, but again, I think in terms of acting as good counsel on projects, you must always keep your eye on that practical ball of keeping your eye on how are we managing the risk going forward, because ultimately it's the public government or the project proponent that will ultimately wear that risk, notwithstanding what the law may or may not be. And it can be also very challenging depending on the Indigenous peoples involved. And again, all of them will approach these issues a bit differently. And then finally, we wouldn't be doing justice to this presentation without mentioning the May. And by the way, we received many calls from clients on this. This actually generated quite a bit of work in the spring. In May 2020, the governments of Canada and BC signed an MOU with the Wet'suwet'en hereditary chiefs, recognizing the traditional hereditary governance structure relating to Aboriginal title lands. The MOU, I think it's fair to say, provides little clarity. There's no express role for elected leadership. And it appears to acknowledge that the hereditary chiefs have a distinct right to govern in their traditional territory. The MOU completely avoids any discussion around how democratic values and the rights of individual Wet'suwet'en citizens fit within that regime. So this raises, and again, this is a trite point, but fundamental questions about what government is actually trying to achieve and do, and where individual rights fit in. Our final point on this slide is reconciliation, and the Constitution of Canada, in our respectful view, requires transparency and it requires prudence. And sort of getting to a quick win on these things, there's nothing wrong with doing things quickly, but these things have to be done right. These are fundamental issues that are being dealt with. So that was a very quick run through on a massive issue that is developing in Canada. I will now pass it over to Aaron.
Thank you, Tom. I'm going to be looking at some of the more recent challenges and issues that we've seen come up with duty consult, specifically funding and triggering the duty consult and how these things are moving. With regard to funding, we've seen challenges across the country and a number of different approaches people are taking. Funding has become a larger and larger topic of discussion and often forms a major part of initial engagement, predominantly between proponents and Indigenous peoples in terms of creating an understanding of what's reasonable, what should be expected. We're seeing things all the way from companies thinking that they can go around sending dozens of notices and the lack of any response without providing any sort of capacity funding means, that's all they had to do. They sent the notice. It was up to the Indigenous party to take their own resources and look at that and provide feedback or not. At the other end, we have Indigenous parties who, may come up with significant expectations regarding capacity funding. There's a number of Indigenous groups across the country who are now instituting processing fees and those type of things. There is not any sort of consistency across the country, but it's definitely a growing issue and one that tends to take up a bit of time on every one of these files. The concept around funding, it's been around and it's gained more and more presence in the conversation. Engay, Northwest Territories Court 2014 started talking about the importance of funding. Seguin decision from Ontario Superior Court in 2017 was quite interesting. Now, those are both lower courts, but in the Seguin decision, they said to have meaningful participation and consultation, a First Nation must have sufficient expertise and resources, highlighting both the need for expertise, we typically think of technical expertise, but there's questions about what else may fit in there, legal expertise, and resources, and within that kind of area, we contemplate even the most basic sort of office being able to process, being able to take things back to chief and council or other leadership as appropriate. The most helpful direction, or I guess the most critical direction, since it applies to the entire country, came in 2017 from the Court of Appeal, and it highlights both how this issue is being seen and recognized by the Supreme Court of Canada, as well as how it can be an opportunity. In Clyde River and both Chippewa of the Thames, Chippewa of the Thames, the court held up as a good example of consultation. Funding was provided, reasons were provided. There was a significant amount of engagement. In Clyde River, which the court contrasts, a number of challenges, things not translated into appropriate languages, you know, a lack of consideration of the treaty right itself at issue, focusing predominantly on the environmental issue. But what's very interesting and very informative of Clyde River is the court said, had the proponents had the resources, the results could have been very different. And I've trimmed that and probably incorrectly, but the idea being simply that if the community had had the ability to engage technical people, to have a proper understanding of what was happening, this decision could have ended up very differently. Again, it is a helpful reminder that capacity funding can help everybody here. While often I think it's easy to think about, well, where's the money going? Is it being used effectively? It can be excellent evidence for proponents that they've engaged meaningfully and they've given every opportunity to the Indigenous party to understand and be able to comment and engage meaningfully. So that's it for funding. I want to move now to understanding triggers for consultation. And this is another issue that's moving fairly quickly. The last one, obviously, that's from decision in 2017, the Supreme Court of Canada. This is predominantly things that are showing up last year and this year, within the last 12 months. And I've had an opportunity to work with Tom Isaac on one of these cases. It's an exciting and interesting area of law, which is, what is the trigger for the duty to consult? Where does it come up? Traditionally, everybody's always said the trigger is low. The Supreme Court of Canada in Mikisew said that the trigger is low, but what does that mean? And if you look at the duty to consult as originally framed in 2004 by the SEC's decision in Haida, there wasn't a trigger expressly implied. When the Crown has knowledge, real or constructive, of the potential existence of Aboriginal right or title and contemplates conduct that might adversely affect it, that was enough to trigger consultation. Again, there's no suggestion that the impact has to be significant or anything like that. It was, on a straight reading of it, any type of activity that could impact or adversely affect an Aboriginal right or title would trigger the duty to consult. That was picked up in 2010 by the Supreme Court, which rephrased it into 3 rules, which again restate Haida: real and constructive knowledge of the Crown. The Crown contemplates conduct, and that conduct may adversely affect Aboriginal title. But it's that third point that the court in 2010 revisits and adds content to. Into part 3, what is adverse effect? And the court goes and says mere speculative impacts are not adverse effects. And it must be an appreciable adverse effect. So this is a new addition in 2010. And the adverse effect must be on the future exercise of the right itself. And again, now we're left with this ambiguity. What is appreciable? How does that fit in? We can, it's almost, there's almost a limitless opportunity to tie things together and say, oh, well, this will have an impact here, this will have an impact here. But what really triggers this threshold, and how can we distinguish that and decide when something hasn't triggered the threshold? So this was first significantly revisited in a decision that both Tom and I were counsel for. It is PEI Court of Appeal 2019. This came out in November of last year. And the court in that case, the Court of Appeal, looks and says, yes, there is a threshold. Not every government contemplated action triggers the duty to consult. The trigger is low, but there is a threshold to achieve. And when the court's looking at what a appreciable impact is, the Court of Appeal says it has to be material, to have qualities of appreciable, real, and non-speculative. Again, giving some flavor to what exactly triggers. Now, just as a bit of background, we don't have much time, but in the facts behind the situation, or the government was trying to sell a golf course that was over 300 acres large. All of Prince Edward Island is subject to a title claim. by the Mi'kmaq PEI. And they said, well, if you're going to sell this land, you're going to trigger the duty to consult. But they didn't provide any specifics with regard to that land, of why the land was unique or special or significant in any way. They went in purely based on an argument that because they assert title to it and because it is land in PEI, there is a duty to consult. And the court said, no, you need something more substantial than that. That on its own is not enough to trigger a duty to consult. And the lower court, which the Court of Appeal followed, was a little more specific in terms of, 300 acres seems like a lot of land, but compared to all of PEI, it is quite immaterial. That was followed up by a decision very recent, early in the year, Yukon Court of Appeal, which is made up of the same bench as the BC Court of Appeal. In that case, the issue was harvesting, and whether, because the Ross River Denna had asserted title to an area, the Crown had to consult with them over harvesting permits that would allow people to enter those lands that were asserted as Aboriginal title. This case didn't deal with impacts to wildlife itself. In this case, again, the court goes back and says, to trigger a duty to consult, there must be an appreciable adverse effect. And it was Ross River Denna had to show that would be that would occur. It rested on identifiable adverse effects to the subject matter of the claim. And then again, this was followed very recently. We don't have a slide for it. Late July, another decision, BC Court of Appeal, where the court in that case said a marginal potential adverse impact is not an appreciable impact. So, we're seeing all these together. This has been, I guess, 9 months, and we've seen 3 significant Court of Appeal decisions, all speaking to appreciable, and it is helping to give some flavor and direction when we hit these questions on what will trigger the duty to consult. And, when we start looking at pretty small impacts, very basic government operational type decisions, low-level permits, I think there is an increasing argument that duty to consult may not be triggered. The caveat of that is, of course, and this was brought up in the PEI Court of Appeal, every circumstance is distinct and will need to be evaluated on its own merits. So that's it for my section.
Thanks very much, Aaron. That was great. Grace and I are now going to talk about the UN Declaration on the Rights of Indigenous Peoples. We'll talk a little bit about putting UNDRIP into the Canadian legal context. We'll do a bit of a breakdown of what's going on in British Columbia with the legislation, and then we'll wrap up with a couple of comments of again trying to put this discussion into context. This has been a particularly hot issue over the past few years. As I'm sure all of you know, UNDRIP is an international aspirational document that, certainly those who drafted it, was designed to be a global benchmark for Indigenous rights, economic, land, social rights, and, for example, also including the concept of obtaining the free, prior, and informed consent of Indigenous peoples before actions are agreed to by or consented to by government that could adversely affect Indigenous rights. UNDRIP was adopted by the UN General Assembly in 2007, and at that time Canada voted against it along with Australia, New Zealand, and the United States on the basis that Canada actually wanted to implement it into domestic law, but because UNDRIP was drafted so broadly, and again, I'm not doing full justice, this is a very long presentation to give, but the way it's drafted, it was drafted as a typical international declaration, which is very broad language, and the language of UNDRIP to this day doesn't align with the 70+ decisions of case law that we have from the Supreme Court of Canada on Section 35. Different language is used, land rights in UNDRIP versus Aboriginal title in Canadian law, and the concepts are completely different. I should note that back in 2007, a majority of states that actually had Indigenous peoples, according to the UN, there were 88 at the time, only 42 voted in favor of UNDRIP. And of those 42, most of those put caveats. And one of the big caveats being, subject to our internal constitution. So in 2010, Canada does endorse UNDRIP with the same type of caveats that the others did of subject to our internal laws and constitution. And then in 2016, Canada announced its full support of UNDRIP. My own argument is that, you know, when you break down what happened in 2010 versus 2016, the messaging looks different, but in fact, in substance, there's no difference. The same caveats continue to apply in 2016, of course, i.e. it's subject to Canada's constitution. And in Canada's case, we have the single most sophisticated legal regime dealing with Indigenous rights of any state on the globe, flowing from Section 35. We'll just take a quick shift now. In 2016, and again, many of you will be aware of what was called Bill 262. The NDP Member of Parliament, Romeo Saganish, introduced a Bill 262, an act to ensure the laws of Canada are in harmony with UNDRIP. And it required Canada to take all measures necessary, that's a direct quote out of that bill, to align all Canadian laws, and again, many of you will know this, under the Interpretation Act, that means every federal law, every federal regulation, some 30,000+ pages of law, had to align with all 76 paragraphs of UNDRIP. And some of you will know, again, thanks in large part to Aaron's work on this, we made a presentation actually to the House of Commons Standing Committee, where we actually made the point that it would be impossible for Canada to adhere to its own law, that it is not possible to ensure that every federal law aligns with every paragraph of UNDRIP. And we stand by that view, by the way. And by the way, that doesn't mean we're against UNDRIP. It just means that we're trying to be honest about what can actually be achieved, as opposed to what was in Bill 262. It passed the House of Commons, but of course it died in the Senate. What we hear now is that the Government of Canada fully intends to renew its efforts to implement UNDRIP fully at the federal level in the fall of this year. So we'll see what happens. Grace, I'll pass it over to you now to talk a little bit about what's happened in British Columbia.
Great, thanks, Tom. So following Bill C-262, the most recent attempt to implement UNDRIP in the Canadian legal context was by the government in British Columbia with their enactment of the Declaration on the Rights of Indigenous Peoples Act, which I'll refer to moving forward as DRIPA. DRIPA was announced by the BC government on February 12, 2019, and it was intended to serve as the foundation for the province's work on reconciliation. This foundation would respect, promote, and advance the rights of Indigenous peoples, and thus provide a path forward, creating clarity and predictability for everyone in British Columbia. DRIPA, which was developed in collaboration with Indigenous peoples, was introduced on October 24th, 2019, and was then passed unanimously on November 26th, 2019. On its face, DRIPA is a very simple piece of legislation. It's comprised of only 10 provisions and a schedule. DRIPA has 3 stated purposes. First, to affirm the application of UNDRIP to BC laws. Second, to contribute to the implementation of UNDRIP. And third, to support the affirmation of and develop relationships with Indigenous governing bodies. In short, DRIPA was modeled off of Bill C-262 and requires the BC government to align all of the province's laws with the UNDRIP. And as Tom previously mentioned, all of the province's laws means all of the legislation and all of the regulations. Given the similarities between DRIPA and Bill C-262, a lot of the concerns around Bill C-262, which Tom discussed earlier, is also present with the DRIPA. DRIPA as a whole is broadly phrased. Despite imposing several obligations on the BC government, the legislation provides very little detail with respect to the contingencies, the priorities, and the timelines associated with these obligations. This lack of specificity has generated a lot of uncertainty around its legal consequences, and this uncertainty becomes very apparent when we examine some of DRIPA's key provisions on the following slides. So the first example we have here comes from DRIPA section 1 sub 2, which states, for the purposes of implementing this act, the British Columbia government must consider the diversity of the Indigenous peoples in British Columbia. particularly the distinct languages, cultures, customs, among other considerations. The issue here is that in British Columbia, there are approximately 200 distinct First Nations and the Métis. Each of these Indigenous groups have their own unique cultures, customs, history, practices, and traditions. It therefore becomes inevitable that differences of opinions and viewpoints between these diverse Indigenous groups will arise during the government's consultation and cooperation process. DRIPA does not contemplate or explain how and to what extent the British Columbia government will adapt its consultation and cooperation process in the face of such differences. This lack of specificity creates an enormous uncertainty around how the British Columbia government will go about fulfilling its obligations in Section 1, Sub 2. The second example we have here comes from Section 3 of DRIPA, which states, in consultation and cooperation with the Indigenous peoples in British Columbia, the government must take all measures necessary to ensure the laws of British Columbia are consistent with UNDRIP. The standard of all measures necessary is a very high and inflexible one. It requires the British Columbia government to do whatever it takes to align the province's laws with UNDRIP, and it offers no room to derogate from this requirement, even in the face of competing interests. One would assume that in implementing DRIPA and aligning the laws of British Columbia with UNDRIP, the British Columbia government would adopt some flexibility in their approach, because it would be practically imprudent for the British Columbia government to do whatever it takes without giving due regard to things such as cost and efficiency, among other things. However, as drafted, Section 3 and the rest of DRIPA doesn't allow for this flexible interpretation. The provision contains no qualifications and no guidance on what the standard of all measures necessary entails in the context of DRIPA, or when a determination can be made as to when all measures necessary has been exhausted and when the government of British Columbia has fulfilled this standard. Tom, I'm going to pass it back over to you for the next example.
Grace, thank you so much. Under Section 4.1, the government must prepare and implement an action plan to achieve the objectives of UNDRIP. And again, one of our points here is there are no stated objectives of UNDRIP. And so it then begs the question along the lines that you've already heard from Grace of, well, what is it? And this is now part of the legislation. The government must prepare an action plan, but what are the objectives? And so our view, and you're going to hear on the final slide, that we do believe that reconciliation requires specificity, to use the term that Grace used a couple of times earlier in this presentation, and couldn't agree more, that that is actually being more respectful of reconciliation in our view. So the first sub-bullet here is, so this is Article 19. Many of you will have seen this. This is one of the examples of FPIC, free, prior, informed consent, being used in UNDRIP. So this is one of the provisions that British Columbia, and presumably at some point Canada, says all its laws has to be consistent with. States shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions. By the way, we'll stop there. What does that mean in terms of hereditary governance that we talked about earlier? In order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. Now, for those of you familiar, which again, knowing who's online, I think almost all of you are probably mini experts at least, or full experts on FPIC. That's what one of the examples of what FPIC is. And we know the UN has produced a business guide that describes what consent means. Consent means consent. It doesn't mean consultation. Look at what the government of British Columbia has on its website about what free, prior, informed consent means. So that's the next sub-bullet. And the reason we've got is here is try to put these two concepts together. You've got the UNDRIP saying one thing about FPIC, and here's what the government of BC has. Free, prior, and informed consent recognizes Indigenous peoples' rights, interests, and voices. It means early, deep, and meaningful involvement of Indigenous peoples on matters that affect their peoples, communities, and territories. And again, with respect, we disagree. that isn't what FPIC means. That may be what people would like it to mean, and that's okay to have a discussion, but that clearly is not the predominant definition of FPIC, and certainly not according to the United Nations. And we just, again, we're picking on it a bit, but it's a practical example of the kind of uncertainty that Grace was speaking to earlier. In terms of the big picture, look, the overarching goal of DRIPA is to advance reconciliation. We, of course, all of us, I think, support that. Certainly the industry clients that we work with, I don't think we've worked with one that would not be supportive of advancing reconciliation. But we know that reconciliation has to be more than simply platitudes and recognition. It has to be grounded in practical actions. Otherwise, it's simply rhetoric. And rhetoric doesn't help Indigenous peoples. We would argue it doesn't help public governments over the long term. It may achieve short-term objectives, but certainly doesn't help over the long term, and certainly doesn't help Indigenous peoples. UNDRIP was not designed by its nature to be a specific legal instrument to be directly implemented as law. Again, for those of you who've studied international law, you'll know that about the nature of a declaration. It was needed, given we have many states on the globe that do not respect Indigenous rights. But we need a specific, nuanced, and flexible piece of legislation that understands the nuances of Canada. And I will make this comment that when you look at Canada globally, and I'm not here, to be an apologist for our country or to say that we've got it fixed. We don't. We have so much to do, whether it's missing and murdered women, whether it's the residential school, the lingering effects of residential schools, whether it's clean drinking water on reserves, whether it's understanding the duty to consult better in the honor of the Crown. But make no mistake about it, Canada has the single most sophisticated regime on the planet built into its constitution to protect Indigenous peoples. And again, many will argue, and you'll hear us argue from time to time, that it maybe doesn't go far enough. But relative to the rest of the world, there is no close second to Canada. And I think this is another part of sort of telling the whole truth about the discussion around UNDRIP. Any discussion of reconciliation, including UNDRIP, demands truthful, thoughtful, and honorable dialogue and action from all parties involved. And so with that, thank you, Grace. We will pass it over now to Jeremy to talk about some recent trends in regulatory and environmental law. Over to you, Jeremy.
Thank you, Tom. I'm very pleased to be here and looking at the great list we have. I know the pandemic's brought some challenges, but it's fantastic that so many of you have been able to join us today. My colleague Viviana Berkman and I are going to give an overview of some recent trends in regulatory and environmental law. And in our field, there's been a lot of doom and gloom in recent years. Viviana and I are working on a multi-billion-dollar project, and we're going to focus on linear infrastructure projects, things like pipelines or rail, hydro transmission lines, or roads that affect a lot of different lands, Indigenous communities, and other stakeholders. But these principles are applicable to any project, including site-specific projects like mines. And what we found is that the regulatory process has got longer and longer. I've been working on the same project for 8 years. It's coming to the regulatory process being longer than both world wars combined. The environmental assessment on the record, I've been told, is one of the largest on Earth. And even though the project's under construction, after 8 years of review, the regulatory process is not ended. So that's the part of the past. But looking to the future, what we want to give you is some very specific guidance on strategies for success for regulatory and environmental approvals in 2020. And we have some specific feedback regarding recent trends involving Indigenous-led projects, how to navigate enhanced environmental and liability requirements, as well as the new world of remote hearings for regulatory approvals during COVID, and as well as how to start right. We're seeing a lot of new projects actually come across our desks, a lot of them proposed by Indigenous groups or significantly backed by Indigenous groups. And we've come up with some methods and strategies that these projects can be designed in order to ensure their success. So with that, I'll turn over to my colleague, Viviana, to address the first two slides, and I'll come back for the end. Thank you.
Thank you, Jeremy. So the first trend I want to talk about relates to Indigenous-led projects and how they can benefit from streamlined regulatory processes under the new Impact Assessment Act. So over the last few years, projects led by Indigenous proponents or with Indigenous participation have been on the rise. So you can see a few examples on the screen. There's a 2016 collaboration between the Musqueam First Nation and Encanto to develop an unreserved potash mine in Saskatchewan, an acquisition by Miksuk Cree First Nation and the Fort McCabe First Nation of a 49% interest in Suncor's East Dunk Farm, an acquisition by 7 First Nations of a combined 40% interest in the Fort McMurray West Transmission Project in Alberta in 2019, and finally the proposed Eagle Spirit project for approval of a First Nations-led energy corridor through Alberta and BC, where the participating First Nations will be major equity holders. So under the new framework established by the Impact Assessment Act, Indigenous proponents can propose streamlined regulatory processes for approvals of their projects. So just to give you a very brief background on the Act, as you all know, it was passed last year as part of Bill C-69 to replace CIA 2012, and it establishes the federal process for impact assessments. So one feature of the Act I want to particularly highlight for Indigenous projects is that the Act contains a definition of jurisdictions under the Act, and it identifies certain Indigenous jurisdictions. And this means that these Indigenous bodies can exercise delegated powers under the Act. And so what does this mean in practice? And the interesting thing is that the Act is not prescriptive. And so it is up to the Indigenous proponents to propose solutions that are targeted to their projects and to engage early with the agency to implement collaboration schemes. Now, it's worth noting that Indigenous proponents likely do not fall under the definition of an Indigenous jurisdiction under the Act, but the Indigenous governing bodies do. And so what this means is that if Indigenous proponents want to benefit from the streamlined processes under the Act, they should ensure that they maintain independence from the Indigenous governing bodies that they relate to. And so just to give you a couple of streamlined solutions that proponents could, for example, the delegation to their Indigenous governing bodies of the compilation of summary issues insofar as those relate to Indigenous issues. They could request delegation of the creation of engagement plans for the process. They would be particularly suited to lead the creation of studies incorporating Indigenous knowledge. And finally, they could request to draft portions of the impact assessment report, insofar as those relate to Indigenous impacts. And so really the possibilities are endless, and it's up for the proponents to identify the solutions that work best for them. A second trend that I would briefly like to discuss is the new Alberta Liability Management Framework and how it enhances requirements for operators. So as you all probably know, the framework was announced last July, and its purpose is to enhance the reclamation of sites while providing more flexibility to operators and creating opportunities for investment. Now, while it remains to be seen how the framework will operate in practice and whether it will achieve its proposed goals, it has some key proposed features. So the first feature is that it will implement a more fulsome assessment of an operator's financial health. And that is done by not considering only deemed assets and deemed liabilities, but also just the overall corporate health of the company. So it will take into account, for example, financial statements and other records. The second feature of the framework, and this is under the licensee special action, is that the Alberta Energy Regulator will be empowered to proactively approach and provide guidance to distressed companies with the purpose of preventing or limiting the transfer of assets to the Orphan Well Association. And the way this is proposed to be done is by giving access to lending, insolvency, and other industry experts. The third feature I want to mention is the inventory reduction program. which establishes annual spending targets for companies aimed at reducing inactive wells in an operator's inventory. So what's interesting is that this program allows for efficiency by enabling companies that operate within the same area to team up and share costs for site closures. Finally, under the framework, landowners can nominate sites for cleanup activities. So the AER will assume an active role in managing these nominations, assessing them, and making a final determination. And finally, just very briefly, what I want to mention is that the framework and related initiatives increase opportunities for investment. And two measures that are worth mentioning are the site rehabilitation program, which is a $1.2 billion fund to be used for grants to Alberta-based service contractors to perform abandonment and reclamation work on oil field sites. And the second one is the Orphan Wells Association authority to enter into agreements with oil and gas producers and service companies to abandon and reclaim existing orphan sites in its inventory. Now, Jeremy will discuss a few other trends. Thanks.
Thank you, Viviana. So we are working on right now about 12 different federal regulatory hearings that are proceeding remotely. So a lot of times it would look like this, using Zoom or Microsoft Teams as a way to not have in-person hearings. This is the same with courts and regulators across Canada. But what we want to point out is that, in my view, this may be more of a new normal for regulatory. Regulatory is typically hearings in remote communities in different areas of Canada, and the remote tools have actually increased participation. So has allowed different Indigenous groups or landowners and environmental groups to participate from different places. So what we're seeing is key things is that the processes will be flexible for regulators. I think courts have been more prescriptive in terms of remote processes, but regulators have allowed video, telephone, written, or some hybrid of all three. And our recommendations to proponents is to try and accommodate especially Indigenous groups and landowner or environmental group participation, and be flexible through the process, especially with things like exhibits and whatnot. So there's different strategies for success. And I'd also caution that the efficiency of using these remote processes can also lead to inefficiency. If you're in a remote community for 1 week to do a hearing, that hearing will be done in 1 week. But if you're on Microsoft Teams, it's very easy to adjourn and feel that you can finish later. So we'd recommend that proponents also be aware of that. Our last 2 points. First, we're seeing a trend of greater need for planning and Indigenous consultation and engagement regarding environmental and socioeconomic assessments. This is the early assessments. Basically, this deals with who to consult, and we're seeing in our files is that oftentimes different Indigenous groups will rise deep into the regulatory process, sometimes near the end, and this causes concern for proponents to know whether they've done the consultation correctly or if they consulted the right groups. Our advice in general is this: consult early, use government lists regarding groups to engage with, but also don't rely on those lists. If there's other groups that your experts think should be engaged with, or groups that just identify potential impacts, we'd recommend at least looking at that engagement. And to Arn's presentation, there's no formula of funding and other issues, but it should be looked at on a case-by-case basis. I would say in general, just be consistent and be reasonable, and think about litigation at the end regarding a company's decision whether or not to consult with a particular group. And to wrap up, my last point is that we also need new strategies for linear infrastructure projects. This is what I call the chicken and egg dilemma. We have several new major infrastructure projects. Viviana mentioned Eagle Spirit, which is maybe a $20 billion project if built. And at the early stages of these projects, it's hard to know their design because the projects are simultaneously trying to design the regulatory process and going out for investment. What we recommend is early develop a high level concept of the project, so start, end, and major components, and engage with regulators early. We participated in these meetings, early project planning meetings, where we've got feedback about potential processes. But if the project does not have the basic information, it's hard for regulators to give feedback. In my view, they've been very open to different processes and streamlining provisions of the Impact Assessment Act, for example, but those are not available unless the project has a minimum level of detail. So those are our 5 tips to basically achieve project success in 2020. And I'll call on, I think it's Mary and Jared are talking about Aboriginal issues and litigation. Thank you.
Thanks, Jeremy. So I will be presenting first. My name's Jared, and before turning it over to my colleague, Mary Buttry. The purpose of this presentation is to provide a brief overview of some current issues and trends that we're seeing in Aboriginal litigation, particularly as it relates to Aboriginal title, following the seminal decision of the Supreme Court of Canada in Chilcotin. And the purpose of doing so is to draw attention to various strategies and issues that need to be considered in what is a rapidly developing and changing litigation environment. Chilcotin is the starting point for this discussion, and it's seminal in that it articulates what the incidents of Aboriginal title are. And so in Chilcotin, the Supreme Court of Canada clarified that the incidents of Aboriginal title include the right to decide how land will be used, the right to enjoy and occupy the land, exclusive right to possess the land, right to economic benefits, and the right to proactively use and manage the land. Now, what's also important is that the Supreme Court of Canada articulated interests that are potentially capable of justifying an incursion on Aboriginal title, and these incursions are very poorly understood in this context. These include the development of agriculture, general economic development, and among others, the building of infrastructure and the settlement of foreign populations. And this gives rise to what is a current trend in Aboriginal title litigation, and that is the assertion of an Aboriginal title claim over and in respect of land that's held by private landowners in indefeasible title. And so Chilcotin raises the question, because this wasn't at issue in the case, whether or not a fee simple interest can be subject to an Aboriginal title claim. And this question is unresolved in current Canadian jurisprudence, but it arises in at least 3 claims that are currently in various stages of litigation. And these cases are notable for that reason and are worth paying attention to, because they may result in the sort of a resolution and delineation of the interest, that being the interest of Aboriginal title and fee simple title. And so these cases are the Coquitlam First Nation, which is a claim that was commenced in 2016, and it involves various lands, including Colony Farm Park. This is a piece of litigation that Cassels is involved in. So Mary, Tom, and myself sort of leading the litigation on behalf of one of the defendants in this case. There's also the Cowichan Tribes litigation, which is in a fairly advanced state of litigation, and it involves an Aboriginal title claim over various lands, some of which include the city of Richmond. And then there's the Council of the Haida First Nation, which is an Aboriginal title claim over and in respect of Haida Gwaii. So with respect to the Coquitlam First Nation claim, as I said, this is the case that Cassels is heavily involved in, and we act for one of the defendants. The Coquitlam First Nation has asserted a claim of Aboriginal title over and in respect of land that's held not just by the provincial crown, but also by private landowners who hold title to various lands in fee simple. And in respect of those lands, the plaintiff has asserted as among the relief sought that any grant or patent or certificate of indefeasible title held in respect of any of the lands in the claim area, including the fee simple lands, be canceled or transferred to them. And as I said, Cassels is retained by one of the title holders, and we've advanced a number of defenses in respect of this claim. These defenses include the inconsistency of Aboriginal title with the fee simple interest, the novel defense of extinguishment, which is predicated on the idea that the granting of fee simple title would have extinguished any Aboriginal title interest, and then in the further alternative, the defense of displacement. These defenses have been raised by other defendants as well, but they are really novel and raise unresolved legal issues. which we'll discuss in the next slide. The plaintiff First Nation, Coquitlam, brought an application a couple of years ago to strike these defenses, primarily on the basis that they were novel and that they didn't have any foundation in current Canadian jurisprudence. This application was ultimately dismissed, partly and primarily for those very reasons. There's no binding authority that has squarely addressed this intersection between Aboriginal title and fee simple. It was not plain and obvious that the defenses were certain to fail. An innocent third party title holder is entitled to plead the defense of extinguishment, and any attempt to resolve these significant constitutional issues in a summary manner through an application to strike would be inappropriate. So the takeaway from this case is that, without commenting on the merits of the defenses, there is now jurisprudence that has expressly stated that private landowners can assert the defense of extinguishment. And I will turn it over to my colleague.
Hi, everyone. So back in 1997, a case that you probably all heard about, the Delgamuukw case, actually concerned the definition, the content, and the extent of Aboriginal title. And you'd think, since it happened in 1997, that there would actually be some clarity as to who ought to participate in litigation regarding Aboriginal title. Well, I think you've probably just understood from what Jared has said and what I'm going to expand upon, that unfortunately that's not the case. So in the Coquitlam case, which is the case that Jared was just talking about, it's more formally known as the Gisbret versus British Columbia case. There was an application by the province of British Columbia to add the Attorney General of Canada as a party. And that is because some of the title was transferred by the Dominion of Canada at the time. And the application, notwithstanding that, was dismissed. The court determined that all of the issues can be adjudicated with the involvement of the existing defendants, that the province is fully capable of defending this action, and that reconciliation requires litigating the most effective and timely way possible, and that Canada's participation was determined to be unnecessary to ensure that all matters that have been put in issue by the KFN will be effectively adjudicated. And so, because some of the grant came from Canada, it could be considered to be a bit of a surprising decision, but I think reflects a balancing that the court is trying to embark upon in Aboriginal issues. And that is, these matters are already extremely complex, time-consuming, and expensive. In this matter in particular, I think there's a 90-day trial scheduled to start next spring. And in the Cowichan matter that Jared referenced, I don't know what their original estimate was, but they've blown past the original time estimate of that and are still continuing because of the importance of these issues. And so they're trying to balance actually having these issues brought before the court in a timely manner versus the interests of the parties. And so despite the dismissal, it is the subject matter of an extant appeal that will be proceeding, likely not before the new year, just because of the way that the Court of Appeal goes with respect to timing and delivery of material. What's interesting about the decision to dismiss the appeal, to dismiss the decision not to include Canada, is that presumably if there are issues that weren't raised in the trial, they could be raised by a third party that may be affected by that decision down the road. So you have to question, when a court is trying to balance the interests of the parties, if it would result in further litigation after a decision is rendered, is that really helping the litigation proceed quickly? So in the context of Aboriginal title litigation, one of the thing that's been highly emphasized is reconciliation. And reconciliation, which I'm sure you've all heard, is a very important construct of Aboriginal law generally, and it requires the consideration of, we say, and I think the cases have recognized, the consideration of any intervening rights of innocent third parties. So historically, people consider reconciliation to be between two parties, the government and the Aboriginal people, who are of course very important and necessary parties. But because the issue of the effect of Aboriginal title on private landowners has not been determined, those people may also need to be party to any reconciliation discussion that happens. And this has been recognized by a number of decisions in Canada, which has which are listed there, including what we consider to be sort of the seminal case that started it all, which is the Delgamuukw case. So it may not be that this issue can be resolved, even if it is resolved in the courts, if the third parties, we're calling them innocent third parties, but perhaps a better description is private landowners, but the people who aren't party to the litigation are going to have to be at the table. And it really will be a balancing of interests as to, I think, to do the least harm to all of the parties, considering this unusual landscape. And so recently we've talked about the issue of involving expert witnesses to essentially be pose a weather eye to these issues and talk about the historical context as between the parties, and to really be someone who can assert the historical rights or facts of this land ownership. And it is important because understanding the historical context is essential to balancing those rights, as we've said. And then just to the last slide, I think it's my last slide. Good. Conclusion is, as a result, our thought is that reconciliation is going to continue to play an important role in litigation issues, and may actually proceed side by side with the litigation itself, because there are so many unresolved issues in Aboriginal litigation, especially as it relates to title and fee simple title as private landowners participate. And so I guess the takeaway from the litigation slides are that the guidance is we're still proceeding many years after the original cases very carefully with respect to fee simple title and Aboriginal issues, and we are trying to do so in one that will do the least injustice to all parties involved, and may actually require that we all step back and pay more attention to reconciliation and consultation.
Hi everyone, my name is Emily LaHaye and I'll be presenting today on recent developments in Métis self-governance. Before I start, I would like to just remind you that if you have any questions, you can put them into the Q&A and we'll have some time at the end of the presentation and we'll be happy to answer any questions that you have about any of our presentations. Also, just before I start, I know that we are all gathered remotely today, but I'd like to acknowledge the ancestral territory that I practice on, the Coast Salish, the Tsleil-Waututh, and Musqueam Nation. So today, I'm just going to do a brief overview of who the Métis are, both culturally and legally in Canada. Talk about some of the self-government agreements and structures that many of the Métis nations in Canada have been putting into place over the last few years. This is something that I've been working quite closely with some of the nations on. I want to briefly touch on how these might affect consultation and discuss land claims as well. So I think it's important to know that the Métis are not just a mixed race individual who is part Indigenous, which I think is a commonly held view of many people. Métis are distinct peoples represented under Section 35 of the Constitution, and they have equal rights as those who are First Nations and Inuit. The Métis really descend from a distinct culture that arised from Indigenous women and European Côte d'Ivoire coming into the country. And there is a very distinct culture, and this is important, as well as customs, language, and all of that, which are many of the things that we use to determine what a Métis or an Indigenous right is. Powley is a case from 2003, and this really is the first Métis Aboriginal rights case. It's a very important case, and in that case, we not only define what a Métis right is, but the case also looks into who is entitled to those rights. case involves hunting, but really it has been used to determine Métis rights, not just involving hunting and harvesting, but basically any right under Section 35, which really relates to the Métis governance discussion that I'm going to be taking you on today. So on June 27, 2019, 3 of 5 Métis nations that fall under the Métis National Council, Métis Nation Saskatchewan, Métis Nation Ontario, and the Métis Nation Alberta, signed a historic agreement with the Government of Canada. And this was the Métis Government Self-Recognition and Self-Government Agreement. It is probably the most significant step toward reconciliation between the Canadian government and Métis in over 130 years. And this is a major step toward guaranteeing rights to land, resources, education, culture, and really, most importantly, I think, is the self-government aspect. What's important for you to know as well, in this agreement, there's several steps that the nations must take before legislation is passed that formally recognizes these nations as governments. Because I will remind you that unlike the Indian bans under the Indian Act, many Métis nations, well, all Métis nations, are not recognized in the same way. So this legislation will recognize them as an Indigenous government. Upon signing this agreement, Canada immediately recognized that these signatories were mandated to represent the Métis within their provinces, and that the Métis nations had the inherent right to self-government. So what does this mean for you and any duty to consult and potential land claims, which really it's important to know where land claims are and where, or if you're thinking about the duty to consult and how this might affect your clients or yourself as a project proponent. So with the Métis, the scope of a land claim is much broader than what we're seeing with the First Nations. And this is because, as I think you've probably picked up on, the Métis governments that we work with, a lot of us, are really provincial. So when you're talking to the Métis Nation Saskatchewan, that is a very large area. So when you are looking at how you might be approaching the Métis Nation Saskatchewan, you're looking at a bigger scale in terms of the number of people, the type of, like, the broadness of the land, and also the types of resources that this nation might be able to provide you as well. Currently, outside of litigation, the Métis don't have any formal means of pursuing claims related to Section 35. However, a number of the nations, actually I believe all of the Métis nations under the Métis National Council, have rights and recognition tables with the Canadian government, which is the way right now that they are pursuing any type of comprehensive land claims. The current comprehensive land claim policy deals with outstanding Aboriginal title, but it's restricted to First Nations. The current specific lands claim policy is restricted to First Nations. We're hoping, and there have been attempts to create a specific land claims process that will deal with Métis claims, but that is not quite completed at this time. So current challenges that we've noticed right now, one would be that is consulting with a number of non-Section 35 people, as Daniels and the interpretation of Daniels and how that applies to Métis has meant that a number of groups that would not be considered Section 35 Indigenous peoples are asking for consultation and demanding that consultation. So I think it's always important to consider if this is a Section 35 people as under Powley. Canada is still unclear with this approach, so if you are a project proponent, you might not get the type of guidance that you would expect from Canada on when and how you should be consulting. This is also the same with the provinces. It is clear to some Métis groups, it's clear that they are Section 35 holders, but some other Métis groups, and I think you've probably seen in the Atlantic provinces and more on the eastern side of Canada, we have a lot of Métis groups popping up, and it is not as clear that they are developing, or rather that they descend from the currently recognized Red River Métis. So there's still questions as to, is that the same culture? Is that what we would consider currently under Canadian law as a Métis group? So that might be something you run into. The provincial approaches to Métis is also something that is a current challenge, I think, on both sides, both the Métis side and the project proponent side. We've seen that it varies greatly between the provinces, how they recognize the Métis, if they see Métis as on the same level of Section 35 rights holders as First Nations or Inuit people. Often you will have particular provinces giving them different levels of rights, while case law as well as the Charter and the Constitution Act clearly states that there is no hierarchy of rights. The Métis have the same rights as the First Nations and Inuit people. And as we don't have a distinct Métis Section 35 rights claim process, we will require that to ensure the path to reconciliation is clear and open and moves forward, as well as path is clear for everyone involved, the provinces, the government, and project proponents, so that we can ensure that reconciliation is occurring.
Okay, thank you very much, Emily, and thanks for everyone for participating. I'll just look at any questions. We've got one here. Who do we ask if the Métis are rights holders in Ontario? Which level of government? Emily, did you want to comment on that in terms of Ontario?
So that's an excellent question. Ontario is pretty unique because you have a number of different groups. I would say that the safest bet is, if you look at the Métis National Council, the member of the Métis National Council that exists in Ontario is the Métis Nation Ontario. They are recognized by the Government of Canada. They have a rights and recognition table with them, and they are one of the signatories to the MGRSA, that agreement that I mentioned. So I would say they are recognized by the Government of Canada as the Section 35 rights representative for the Métis in Ontario. I know there are a number of other groups, but currently, from what I've seen and the work that I've done in Ontario, it is the Métis Nation Ontario.
Yeah, and likewise, the province in Ontario has been very clear about the Métis
Yeah.
Ontario and the recognition. If you have follow-up questions, don't hesitate to reach out to us. You'll see our emails. You're going to get a follow-up email from us. We welcome any comments or any views that you may have, and thanks to all of you. Jeremy, I'm going to pass it over to you to close.
Thank you, Tom. I've noticed we're just overwhelmed by the participation today. I've noticed clients from North BC, Prince Edward Island, Northern Canada. So like our project from coast to coast to coast, we're really pleased to have participants from coast to coast to coast. So thank you for your time today. I'd also like to thank our presenters. So in order of appearance, Tom, Arnd, Grace, Viviana, Mary, Jared, and Emily. I think we had a great overview of Indigenous and regulatory law issues. And in particular, I'd like to thank Alex Clark from the marketing team and Viviana Berkman, who did the heavy lifting with preparing this presentation today. Finally, you will get an email with all the materials, as well as an opportunity to provide feedback. And as you can see on the slide, you can reach out to any of us if you have any questions. Thank you and have a good day. And we will have more presentations coming given the success of this one. And take care. Thank you.